Mr. Bester.
Firstly, for my briefly the review issue, the disciplinary committee review. The outstanding aspect as far as Mr. Motsoeneng is concerned is the issue of costs. As I understand the state's argument, they persist with costs in that application against him, amongst others. And that is essentially the only point we need to address in that.
Do we read, sorry Mr. Bester, do we read somewhere that Mr. Motsoeneng does not oppose setting aside the disciplinary proceedings?
That's quite correct in his position, yes.
Just remind me where that is said.
There is the affidavit that he delivered, that he said he just wanted to deliver place certain facts before the court, and he delivered the affidavit for that purpose. And when he says
where will he find that?
At page 150, as I have,
In those which
the review pages.
review pages.
You see the review page. So his affidavit starts at page 132.
Yes.
And then he raises a number of issues about prejudice that he wants to place before court in that review, and then essentially concludes at page 150, at page 27.5, that he will do this for the benefit of the court, and that he does not wish to enter the fray.
Well, he said he doesn't wish to enter the fray insofar as trying to explain his employer's conduct, but he does appear to, sorry, the acoustics aren't very good here. He says he doesn't want to enter the fray insofar as trying to defend his employer's conduct. He's not going to speak for them, but he makes a number of averments which appear to be directed at showing that the disciplinary proceedings should stand, and that and some of the relief claimed at least should not be granted. And he did file a notice of opposition.
He did, quite correctly, sir. I understand that that specifically was not concluded. He contends that he suffers prejudice, and he wanted the court to take that into account. The instructions were to not argue further. The Lords will know that they've taken over the review by default. When previous counsel was not available for these dates, an aspect that we will revert to in a moment when we deal with what is called the main application. But the essence thereof is that we have been told that he is not entering this matter further, he is not opposing, and then ultimately, of course, the affidavit by the SABC in the main application considered effectively the review, and thereafter, of course, it will be relevant to further consider that matter. So what we are saying is, first, perhaps just in the notice of motion, it simply said that whoever opposes, he didn't further oppose beyond delivering this affidavit. We have not made submissions and reasonable arguments in this matter, and therefore we respectfully submit that effectively, far from raising prejudice, it's not been opposing this review in the practical terms that the warrant the possible in the ordinary course. But of course, what the DA seeks to suggest is that in fact there's a good reason for him to pay the costs together with others, because there was some grand conspiracy. Greatest of respect, no such case has been made out on the papers. The best that Mr. Katz could do is to point to an attachment which suggests that as a board member he could have been involved in some other decision. And of course we know that that's denied. But we also know that in terms of Swissburger and other cases, one can't just go at the last moment to a detachment and say, well, here's the case for costs.
I do recall the point was made in the affidavit as well.
No, of course. That's what I'm saying, Lord. It has been denied on the papers, and the Lord, in fact, pointed out to Mr. Katz in his original argument this morning. Really. What we are saying is to now pin the cost issues on simply an argument like that just does not suffice. So we respectfully say that there's no reason to burden Mr. Motsoeneng with the costs.
But your main point is essentially this, is that he did not oppose it and therefore he's essentially not a respondent
That's correct.
within this particular matter where the review is concerned.
Well, the Lord, in the review, he makes the point that he's the victim of that process. He denies all the grandiose accusations of him being the mastermind behind his own disciplinary hearing. Not based on the papers at all in any event. And he says, but I'm placing my prejudice before the court. Although this is an issue that my employer must explain to the court. I'm prejudiced in this process. That's as far as he took that matter. And once the SABC then concedes on whatever basis, because that's not Mr. Motsoeneng's argument, he simply gets informed that the SABC has decided that it's not going to further oppose the review. It's taken a particular stance, which I will leave for my learned friend, Mr. pt2, to deal with. But that is the end of the matter, as far as Mr. Motsoeneng is concerned. But he does not deal with the matter further. Until this morning, he hears that the DA still seeks to hold him liable for the costs, together with others. Although there is no effective opposition. To simply suggest because he didn't withdraw his notice of opposition, he should pay the costs.
It's a rather remarkable application running to 647 pages, which apparently nobody is opposing. And in respect of whom nobody should pay the costs.
Well, we will leave that to the parties who are really involved in that matter. All we are saying is, effectively, Mr. Motsoeneng did not fight that fight, and he should not be burdened with the costs thereof.
Yes.
And Lord, if I may turn to what Mr. Katz has started calling the main application, which, because the review is no longer opposed, I would imagine is the correct way to describe it. We want to start in a different place with the greatest of respect. We want to start at that point, or with those arguments that Mr. Katz dismissed our man. And he told the Lord, in fact, he introduced much of those arguments, summarizing them as blah, blah, blah. I've made a note of that. And those are the arguments that we would want to address for the two laws. Before dealing with the comments made by the DA on those issues, can I ask the Lords to go to the papers, and then specifically the answering affidavit? First to mine with Mr. Motsoeneng, so these are answering affidavits. I believe the Lords will find that in the papers at page 10. Probably there seems to be filed
768.
Yes, 765.
768.
Well, the
There's a filing sheet and then 768. One will have the actual. Yes, please. Can I at the same time ask the Lords to, in regard to the heads of arguments for this matter, for Mr. Motsoeneng? and then perhaps we can start at page 3 thereof. In the affidavit at page 770, Mr. Motsoeneng sets out what had happened, at least from his perspective, in the run-up of this application being before court today. And the essence thereof, and I won't seek to take the court unnecessarily through the fact step by step, but the essence thereof is that, in fact, as we stand here, the application has still not been served on Mr. Motsoeneng. Now, I'm not suggesting, with respect, that Mr. Motsoeneng does not have notice of this application. Of course, we are here. But what we are saying, there was no service. And it's an important aspect because the DA simply says, it's water under the bridge. You here, let's get on with it. Yet, the whole reason the DA wants this matter to be here is legality, if we understand the DA correctly. It hammers on the issue that legality is at stake in this matter. Of course, it starts with something as fundamental as access to the courts. And it starts with something as fundamental as the applicant having to come to court properly and not by steamrolling respondents into a process and then afterwards saying, well, we've done what we've done, you're here now, let's just proceed with it, and we don't have to explain this.
Yeah, but the argument is this, is that there's no application or substantive application for postponement to Celestina. We're not ready.
Well, with all due respect, that's the wrong starting point. The real point to make is that there is no application for condemnation for not complying with the rules of this honourable court and with the practice directives of the specific court. That is the application that the Lords do not have in front of you. It is not for a respondent in an application where the rules have not been adhered to bring an application for postponement. It's right, it is basic with the greatest of respect, that it is for an applicant who seeks to bring someone else before court to do so in accordance with the ordinary process, and if he doesn't do so, to then make out a case and seek appropriate relief to the effect that its non-compliance can be condoned. And we don't have that. There's no prayer in the notice of motion to truncate time periods, to get preference on the roll, to not serve in the ordinary course, and there still isn't. Even after it's been raised, and in fact even after it has been conceded effectively in the replying affidavit, but strangely not in the heads of argument or the argument.
Well, what the application does say, it's a blended short and long form application, because it says it intends to apply on the 23rd and the 24th of November, and explains in the founding affidavit, you may think it's not a good explanation, but explains why it shouldn't be an ordinary long form application, because the processes of the court and the public protector are being set at naught, and these things must be dealt with expeditiously if the administration of the law is not to be brought into disrepute.
The Lord, all that tells us, with the greatest of respect, is that the DA has arrogated itself the right to decide how and when it can deviate from the rules.
But that is, it is not unusual in this division, I don't know about yours, for applicants who say that there's a reason to abridge time limits to issue a notice of motion which determines a date. It will be then for them to persuade the court on that date that the matter should be heard, and the normal circumstances will be assessed. But they don't have to go to a court separately and say, can we have it heard on the 23rd? They can take their chances and try to explain and justify it.
Well, the law, of course, we don't understand how one can obtain condemnation without first having sought condemnation, with the greatest of respect. But the matter, of course, goes substantially further than simply obtaining, let's call it, preferential date on the role. It goes to the fact that Mr. Motsoeneng has been forced to hastily prepare for this matter. He had to deal with this matter under extremely rushed circumstances and for no good reason whatsoever. It's not explained. In fact, it's not even acknowledged by the applicant. So, if the applicant does not even acknowledge that those things have happened, how can he obtain a condemnation?
But isn't it a matter of considerable public importance that one should not have what, at least on the applicant's case, seems to be a consistent set of adverse findings against Motsoeneng going up to the Supreme Court of Appeal, only to find that within days he is appointed to another very senior position? And one says, well, there comes a point where one cannot simply say that with this public broadcast and against the significance of the Public Protector's report and the orders of the court, this must just follow a long form. People will say the law counts for nothing, it's all games.
Lord, we're not suggesting that the DA could not have asked relief to the effect that it could have come to court on shortened time periods.
Well, if you're making the technical point that paragraph A of the notice of motion didn't say abridging the time limits, that's really not going to be your best point, because the application said we will ask for a hearing on the, we're going to set it down on the 23rd or the 24th of November, and we're going to explain, as they do in their founding affidavit, why they say a semi-urgent timetable is justified.
Of course we submit not that that is the point. That's why we stated it goes beyond simply obtaining that date. And it's a confluence of factors. And that is what we must look at. The totality of what has happened creates a prejudicial situation. For no good reason.
But the totality of what? The totality of what?
The totality of the factors that we have dealt with in the data, that we dealt with in the The first aspect is that there was no service. It does not help the DA to say, well, you now know. Because it is the fact that it became effectively a matter of substantially more urgent nature because of Mr. Motsoeneng only obtaining these papers substantially after the purported date that was given to him.
So, just a moment. Can you get somebody to set this so that it's not lying down like this?
Can we send someone to
Can someone just from the television station just assist us with the microphone here?
Just keep on flopping down. No, it's not going to do that.
Okay, we may proceed.
Thank you. To pick up where we left off, we have an applicant who obtains a date, some preference. It tells the court in its papers that it serves Mr. Motsoeneng at the SABC's offices in Cape Town. That's what it says in the citation paragraph on it does not explain why that is so. The point is taken up.
Isn't there an affidavit from Mrs. Jonker, the attorney for the applicant, that says they tried to serve it on the attorneys of Mr. Motsoeneng, who says, listen, I'm not on brief, so I cannot accept any papers on his behalf. Then she went down to the SABC in Sea Point and asked there at the entrance or reception, who's prepared to accept this on behalf of Mr. Motsoeneng? And 15 or 20 minutes later, somebody very senior walked down and accepted on his behalf.
Well, my lord, if Ms. Jonker thereby suggests that that person, Mr. Motsoeneng's agent, is a matter of law and fact that's purely flawed.
Well, it was up to the person to say, listen here, I'm not going to accept anything on behalf of Mr. Motsoeneng personally, you must go somewhere else.
That person was not his agent. That person could not vouch for his own authority. And there's no suggestion on the papers that that person was in fact authorized. In fact, on the facts before this court, it's extremely unlikely that that would have been the case, given what the law has just pointed out. Namely, that early on, and this is before the application had been issued, the attorney acting for Mr. Motsoeneng reviews asked whether the papers can be served on him. He says, I don't have any instructions. The next thing that happens is it is simply dropped off with a person at the SABC's Cape Town offices.
Well, that's not according to the affidavit by Mrs. Jonker. According to her, she asked if there is a person that can accept this on behalf of Mr. Motsoeneng. And then it appears there was some time lapse and a person came down and it was the person accepted on his behalf. That's according to the affidavit.
But, my Lord, it doesn't matter with respect.
What do you mean it doesn't matter?
That's not proper service. The first thing that we must understand here with respect is Ms. Jonker, on her own version, deviated from Rule 4. Yet she's not given the simplest explanation of why she's done so. Rule 4, firstly, says that the sheriff must serve. And I understand that there were a lot of objections, oh, this is overly technical. But if you would also allow me to take the point through to show how this culminates in prejudice holistically looked at, I will seek to make the point here. But the starting point is, Rule 4 requires service by the sheriff. Ms. Jonker says she served. No explanation why the sheriff couldn't serve. Rule 4 gives a whole list of ways in which the sheriff can serve. Not one of them allows for what the DA's attorney has done in this matter. Not one of them. One can go through them step by step. It was not on him personally. It was not on his agent authorized in writing, which is what the rule requires. It was not at his place of employment, because the rule doesn't say any office where his employer conducts business is good enough. It says his place of employment. And we can go through this list one by one. The simple fact is the applicant has not explained to the Lord why it found it acceptable that this application can simply be taken to the local SABC office and someone there must take responsibility of getting it to Mr. Motsoeneng. There's no dispute that the DA is very much alive to the fact that Mr. Motsoeneng is based in Johannesburg.
So the nub of your argument is the DA is complaining about legality, but they themselves don't follow the law and the rules.
Absolutely, my lords. Now we must not just simply say, walk under the breach technicalities. That is where the matter originated. And what was the one practical consequence of this? Weeks later only did Mr. Motsoeneng get the papers.
One would hardly say that he was at all proactive to find out what was going on there.
My apologies, Lord.
It can hardly then be said that he showed any concern to find out what was going on, because he knew on that day, on the day that the application was served in Seapoint, that the application had been issued and that it sought his removal.
With respect, there are two problems with that. Firstly, there's no evidence to suggest that because they dropped it off, they knew it was there.
Well, the SABC published a press release saying that the application had been issued.
Yes, and that is the SABC. And ultimately, Mr. Motsoeneng did obtain the papers from the SABC. But it does not take away from the fact that he had not been served, so that he proactively, and perhaps the Lord may consider it at too slow a pace, but he ultimately made sure that he obtained the papers. Now, how can it be proper for the applicant to come here on a legality argument and tell this court it is for Mr. Motsoeneng to find the papers that we've issued against him.
Was Mr. Mjavu acting in October 2016 for Mr. Motsoeneng in the disciplinary review?
Yes.
So within a day or two of the application being issued, he is asked whether he will accept service in related proceedings where he is already on brief in this court in another matter. And there's no communication between him and Mr. Motsoeneng to facilitate that obvious form of service.
But
you may say that the DA is not playing exactly by the rules, but Mr. Motsoeneng, on his part, seems to be avoiding receiving a copy of this.
no, Lord, with the greatest of respect, that simply does not stand. There is not a single aspect of the rules, the principles of this honourable court that Mr. Motsoeneng can be accused of not having honoured.
If you say the rules don't require him to be proactive in getting the application, you are right. But I'll put to you a factual proposition.
Yes.
As a fact, in circumstances where you would expect him to display a great interest in what was happening, and having heard that the application was issued a couple of days previously, he seems to have been studious in not getting it.
Not at all, Lord.
So what did he do then?
Let us just break it
He doesn't tell us that he did anything to try and get it. All we know is we must assume Mr. Mjavu either asked him and he declined to authorize Mjavu to receive it, or Mr. Mjavu just didn't even bother to ask his client. We know it was emailed to an email address which your client had been using in relation to the previous litigation and was delivered at Seaport. And was publicly known litigation almost immediately.
But Lord, since when does a party serve by public media?
Well, parties serve these days by email. Service can be effected by email as well.
No, it can't, my Lord, with respect. Not up front unless there's agreement. You have to arrange that once an attorney or once a party is on record and has opposed. You can make that arrangement inter partes, but you can't do so up front. In fact, you can't serve on an attorney who you know otherwise act for a person unless that person confirms his mandate. Now, the best thing that the DA can offer is, well, Mr. Mjavu didn't want to accept service, so we've flouted all the rules as a consequence. What Mr. Mjavu said is, I don't have a mandate to obtain these papers. And the next thing, the media knows more about the application than Mr. Motsoeneng, who's the first respondent and who's the person who will mostly be prejudiced if this relief is granted. And it's a trend in the DA's papers, because basically half the information that's been put to the Lords comes from all sorts of media reports. And we must watch lengthy YouTube to know what the DA wants to include in their papers. With the greatest of respect, a party can't come to court, not serve, on their own version they didn't serve, arrange for a process, and then say, well, it's simply too bad you're here now. Because it goes further. There's correspondence that says, well, what's happening? Nothing comes to the fore. Once the problem is realized, it's not dealt with.
Now, are you suggesting that because, according to you, there was no service, therefore we're not entitled to hear the matter?
Lord, we suggest you. Of course, we know that the doctrine of notice is once he knows, he knows. We're not suggesting that one must look at it on the basis of, well, unless there was proper service in terms of the rules, he doesn't know and one must pretend that he doesn't know. What we are saying is, for the Lords to entertain this application, it requires to be properly before this court. And that happens in one of two ways. The one is if it is done in terms of the rules, and the other is if a party obtains this court's condemnation for whatever extent it has not complied with the rules. But the latter requires them to bring an application and to explain their situation. And perhaps it's appropriate, I don't think we refer to this in the heads, but perhaps I can refer the laws to the Constitutional Court decision in eThekwini Municipality versus the Ngomdana Trust. The citation is 2014, Volume 3, SA 240, that is the decision of the Constitutional Court. It dealt with condemnation for lateness in terms of the rules of that court. But we of course know that the test for condemnation is the same throughout. And the simple point is, for a party to obtain condemnation, it must first give an explanation. It can't come and say, well, the interest of justice so far outweighs what we've done that we need not explain to you why we haven't done what we had to do. If there's no explanation with respect, this court should not even entertain condoning. The issue was raised in the answering affidavit. What comes back in reply? No attempt to explain any of the reasons why it was done this way. Simply a confirmation that the service rules had not been followed, and lamenting that Mr. Motsoeneng did not bother to go find the application against him. With respect, there's not even a suggestion by the DA that it acted wrongly, or it made a mistake, or that it had good reason to do what it did. Without an explanation, the laws with respect cannot exercise your discretion to condone these events. If there's no explanation for you to consider, there's nothing for you to exercise your discretion in respect of. And that, with respect, is the end of that matter. And it is not simply a technical aspect. It's coupled with the fact, of course, that of all the parties who are actively participating, because there's 20 odd others that we don't really know why they have been cited, and they all got the papers before Minister Motsoeneng, as we read the papers. But all the principal players are in Gauteng. We still don't know why this application has been launched in this division.
Well, you don't take the point that you haven't raised the point that the court doesn't have jurisdiction.
No, what we're saying is, it is part and parcel of placing Mr. Motsoeneng in a prejudicial situation, and it is part and parcel of the facts that the court would have considered in condoning bringing this matter in these circumstances before court. Because not only does he not get served, he's 1,200 kilometers away, and he must now try and find papers that apparently had been served where it couldn't be served. So it's all part of a whole process of placing Mr. Motsoeneng in a position where it's made as difficult as possible for him. And by design or otherwise, that is the reality. The DA does not explain why it decides to rather act to its own convenience. And we make the point in the head. So, an applicant doesn't go to a court where it's convenient for it. It goes to a court where it's appropriate to sue the parties against whom it seeks to litigate. And what do we have here? The DA is the only relevant party in this jurisdiction. Everyone else is in Gauteng, and it elects to issue papers here.
Was that also the case in the litigation before Judge Skippers and Davis?
I don't want to say off the cuff that all the respondents actively participating were not here, but I would submit substantially so, yes.
It doesn't seem to have ever been raised as a point of concern there.
My apologies.
It doesn't seem to have been raised as a point of concern there, and what we are, to some extent, dealing with here is are circumstances arising out of previous orders of this court.
With all due respect, we will deal with that. But that is not a matter of jurisdiction. And because of what the law has pointed out, that this previous litigation here, we did not specifically take the point of jurisdiction because that would have been a matter that...
Mr. Bester, where's the seat of the Speaker of the Assembly?
My apologies.
Where's the seat of the Speaker of the Assembly? Of the National Assembly. Sorry, National Assembly.
I heard SABC. My apologies. That is here.
Is the Speaker of the National Assembly a party to these proceedings?
It is. But, and below, I must be clear. We're not saying this court doesn't have jurisdiction. We're saying it's inconvenient and, coupled with the manner in which the matter has been dealt with, it prejudices Mr. Motsoeneng. As we've said earlier, it's a matter of a confluence of all these factors that creates the difficulty. The point has not been taken that this court doesn't have jurisdiction. We are saying he's on the other side of the country. They serve here on some person at the SABC's offices, not in compliance with the rules. And then instead of fixing that, they simply say, well, it's your problem that you got the papers late because you didn't try hard enough to get them. Now, with respect, there is simply not a defense in that statement. So what the laws have before you, with the greatest of respect, is an applicant who tells you that it brings an application on a semi-urgent basis that clearly causes a truncated set of time periods that forces the respondents through that conduct to hastily prepare for this matter. Yet, it does not seek this court's condemnation, and it does not explain why. We've put up the case law, but it's straight with respect. A party, as part of explaining itself to obtain condemnation, also has to explain that the extent to which it interfered with the ordinary civil process is concomitant with the need of the matter, as it explains it on the merits of the urgency argument. You don't have that in the rules, with the greatest of respect. There's nothing to exercise your discretion on, because this applicant simply says, well, we've decided it's so important that we don't have to play by the rules. So ultimately, Mr. Motsoeneng obtains these papers on the 7th of November.
On the 7th or on the 3rd of November?
Oh, yes. Perhaps just clarify. The notice of motion and founding affidavit on the 3rd electronically, and on the 7th, the full set, meaning including the annexes. That's a number of weeks after the application had been issued and supposedly being served. And of course, we then have two further aspects. In the application, it's said that, well, we'll also ask that the review and this application be heard together. Now, we make the point of the heads that because Mr. Motsoeneng did not pursue that fight, as I pointed out earlier regarding the cost issue, that is of limited effect. But it creates a difficulty at the time when the directive is sought and obtained. And here's the first part. The directive that caused us all to be here today was already issued on 25 October. That's long before Mr. Motsoeneng even knew what was this about. He had not yet had sight of the papers. There's no dispute that the member of the K-Bar who attended that meeting was not instructed in this matter. Of course he couldn't be, because Mr. Motsoeneng did not have the papers. He couldn't have instructed his attorney, and his attorney couldn't have instructed counsel. But he was counsel in the review. And of course, everyone involved in the review were also called for that meeting. So he's there, he's effectively an observer. That much is common cause. He also points out that he and his leader, Mr. Sikakane from Johannesburg, are not available on these dates. That makes no difference to what happens at that stage. There's no one to even point out that Mr. Motsoeneng had not yet been served with the papers. And one will assume that the directive was granted and the allocation of the date was given on the basis, rightfully so, one would imagine, that had in fact already taken place almost 2 weeks earlier, when in fact it had not. And then we have a directive that sets out a strict timeline. And on the face thereof, the only thing that is ordinary about it, relative to the ordinary time period, is the time period for the answering affidavit. On the face of it. But, and this is the problem with the service and the distance rules, in fact, Mr. Motsoeneng does not get his ordinary time period for the answering affidavit. He gets it on the 7th, and remember now, counsel must start getting into it, who's not really in the matter because the team who acted in the review and at least had already worked up these matters were, as it was known at the time to the parties, were not available. And in those circumstances, the respondents, including Mr. Motsoeneng, directed to file answering affidavits by 14 November. So he gets the papers the one Monday, he must have it in the next Monday. This very important, very far-reaching potentially, and very voluminous matter, Mr. Motsoeneng is the primary target of the application.
But Mr. Bester, what is this case all about? It's about the remedial action of the public protector not being implemented, isn't it?
No, Lord, it's not as simple as that.
It's not as simple as that, but if you have regard to what the present public protector is saying, regard to page 982, paragraph 14 of the papers, let me read it. Notably, this matter has been the subject of several court applications and hearings aimed at ensuring that the remedial action at issue is given effect to. This was necessary because the SABC and its board steadfastly failed to implement the remedial action taken.
Yes, Lord. And Mr. Motsoeneng is not mentioned in that passage that the Lord has just read. Part of the problem with respect. Mr. Motsoeneng is the one who effectively is at the receiving end of the outcome that the DA is seeking. They want him dismissed. They want him dismissed as an employee of the SABC. There can't be any doubt about that. And they do so, giving him a week to answer to this whole voluminous thing.
Well, that's not quite correct. As you say, he had the founding affidavit on the 3rd, and having just quickly looked at it, I doubt if there's any annexure which he didn't already have in his possession. They were all historical documents which you'd know about. Judge Skippers' judgment, Judge Samela's judgment.
That may be so.
The Nkuna report took up about 100 pages.
No, but it doesn't change the fact that his time period is substantially curtailed. In fact, he's given a quarter of what you ordinarily would have. Because you have 5 days to oppose, you have 15 days, 4 days. He's effectively given 5 core days to answer. So, a quarter of what one is ordinarily entitled to is given effectively in this matter to Mr. Motsoeneng. And the DA says, that's a blah, blah, blah argument. That is how they treat this aspect. It's exacerbated by the fact that he had to obtain new counsel. So it is not simply, Mills, a matter of, well, he's seen all these things. there are reported judgments at the center of this matter, change very little in that regard. He must overnight, and I won't make submission and give evidence from the bar as happens a bit in this court so far today, but it was overnight. He was forced to do so. And here the DA sits and said, well, we have right and legality on our side, so we don't have to be held to the rules of court. And we do not have to afford Mr. Motsoeneng the ordinary courtesies that a litigant is entitled to. And of course, they go beyond courtesy.
I'm not sure that it's as stark as that. The question, if it was apparent that there was prejudice, if there was short service and inadequate explanation, the court might decline to hear the matter at this stage. But isn't that the critical question, since a detailed answering affidavit was filed? And of course we have Mr. Motsoeneng's affidavit in the disciplinary case, which has about 70% of the history already traversed.
And my Lord, with respect, it's not as simple as that. Because it's not just about being able to file an answering affidavit. It's about, beyond that, about the opportunity to properly obtain legal advice. For Mr. Motsoeneng and his legal advisors to properly consider all the aspects, all the angles. He's entitled to a fair hearing. And that fair hearing includes being allowed the opportunity to properly reflect with a legal team on these matters. And what have we had here? Get the papers on Monday, forced to deliver an answer the next Monday. The Friday.
Are you suggesting that Mr. Motsoeneng didn't reflect properly with his legal team on this matter?
Well, here's the problem. We don't know what we don't know. But we don't have to go there because the applicant has not asked your permission to have breached the rules, to have truncated and avoid the rules. So in fact, that condemnation application is the one to which Mr. Motsoeneng should answer with his prejudice. Until there is an application before the Lord, it's asking for that relief and making our case in respect of the aspects that the constitutional court, that court which the DA tells the Lord regulates everything we do here, quite correctly of course, is also the court that says they must make out a proper case for non-compliance with the rules. And the test is stated. I refer the Lords to what is one of many statements in that regard. There's no application, there's no evidence upon which this court can exercise its discretion. So it in fact does not get to the point where we need to debate Mr. Motsoeneng's prejudice. And we have a situation where on Monday he delivered his answer, on Friday he gets the replying affidavit and the DA's heads, and how much time is Mr. Motsoeneng afforded to deliver his edge of argument? He's afforded until the Monday. So he must do this, his legal team must do this over the weekend. And this is not, with respect to rules, a complaint because Mr. Ayayi and I had to work through a weekend. We're used to that. That's what we do.
I just wanted to ask you, what's unusual about the legal fraternity working over weekends?
Exactly. Absolutely, my Lord. That's why we want to be upfront, so there's no misunderstanding. The fact is, it cannot be said that it is fair to Mr. Motsoeneng that he must deal with this very important matter. Not only does he stand to lose his employment, it's effectively a declarator that he is a persona non grata in the whole of the public sector. That is how far-reaching this relief is. And he must rely on his legal team to do so on a Saturday and Sunday. The DA says that's fair. That's access to courts. That's what they say. With respect, that's
well, as supplemented with as supplemented by whatever additional time you've had until now.
Yes, my Lord, that would have been the Monday night, and then Tuesday morning, and then we fly to Cape Town, and through the night last night. That's what my Lord is referring to. So with respect, where is the level of urgency in the papers in respect of which the DA asks a condemnation that can put my Lords in a position where you can be satisfied that in those circumstances, Mr. Motsoeneng has given proper opportunity and it is proper to bring him before court in this matter. We've pointed out this court's practice directive ordinarily assumes several weeks in respect of properly preparing for a matter. From the time that the papers are completed until heads have to be delivered, and then further time until you get a date. So this is not simply a matter of, well, how much time did you get for your answer, and so on. The whole process has been so substantially truncated, yet not a word about that from the DA, or the laws to exercise discretion in their favour, should they have asked for it, but they haven't. Lord, this matter is so important. They are with the greatest of respect to judges on this bench. Yet, Mr. Motsoeneng gets 2 days over the weekend to prepare his head. That simply can't be fair. And this coming from the DA, who argues from some sort of self-found pedestal about legality. If no relief is being sought by a party, another party need not counter it. Mr. Motsoeneng cannot be called upon to justify why he is upset with the DA not sticking to the rules. It is for the DA to first obtain this court's permission. On papers, where the relief is set out, with the reasons for the non-compliance.
Well, you're watching SABC News. It's just gone 1500 hours Central African time. Well, you are watching the live visuals from the Western Cape High Court, where we're hearing the DA's bid to remove Hlaudi Motsoeneng from the SABC. Now, the DA says Motsoeneng is not fit to hold any position at the SABC and should be removed immediately. We do apologize for this interruption.
In a matter that happens all the time, where the whole matter is argued, they're all there, they've all filed heads, they've all filed papers. The court still considers whether it is appropriate to grant condemnation. It's implicit that the fact that the papers have been delivered, that heads have been delivered, that everyone is before court, is not a reason to grant condemnation. It is not part of that pot of factors to take into account. And it's not much law around it, it's really, with respect, a matter of logic. Because a party, like Mr. Motsoeneng here, cannot just decide not to stick to the directive that's been granted. Because quite apart from everything that the DA has accused Mr. Motsoeneng of here, he's in fact the one before court, together with other parties, who have stuck to the rules of this matter. And the DA has not. He's tried his best to comply, and now the DA says, well, he should be penalised for that, because he prepared this here.
I don't think the DA says he should be penalised for that. I think it would accept that if it's apparent from the papers that your client has been prejudiced, we couldn't just carry on. But surely we must form a judgment, having read the affidavits that your client has put up and the submissions. I must say, I read his affidavit very much with an eye on whether it seemed to me that there were things which he was saying, I would have dealt with this in more detail if I had time, or I would have made these investigations, and I didn't find that. I take your point, I don't know what I don't know, but apart from that, There's nothing where he seems to think that with more time he would have been able to put up a better answer.
My Lord, that's with respect not correct, because that conclusion can only be drawn if it was his duty to address the issue. Now, until the DA has addressed the issue and asked for condemnation.
But he does address it. He asks us to strike this matter off the roll for want of urgency, and he makes all the points you make about service and forum non-convenience and the like. It's all done. So he's, whether he needed to or not, he anticipated the case of prejudice.
Of course, my Lord, but what I'm submitting is something slightly different. The Lord seeks to draw a conclusion from the fact that he doesn't say, well, here I don't know enough, or here I don't know enough, that there's no problem. It's not correct to draw that conclusion, because it would only have been so if there was a burden on him to point out all those things. What he does is he says, here are the problems why I'm being brought before court overnight, almost. And the DA has not addressed these issues. It doesn't ask for condemnation. It doesn't explain why is it that they should do it the way they've done. But here's the reason why it's not simply a technical objection that the court can simply ignore. And now again, because it doesn't say somewhere in this affidavit that was hastily done, as complete as we attempted to, because it doesn't say, on reflection, maybe I could have added something here. Merely because he doesn't say that, can't lead to a conclusion that there isn't that thing. Because the problem is, he wasn't allowed the time to reflect on it in the first place. And that is the fundamental problem in it. The Constitutional Court requires the applicant to explain the non-compliance. There's no explanation before the laws with respect. They do not have the evidence before this court to have the conclusion drawn that they're entitled to be here. It doesn't help to say, well, it's a very important matter, so probably it wouldn't have mattered what the reason was. Because that's lip service to the test. One can't preempt a conclusion on the basis that you don't have the evidence. Because then, of course, it becomes better for an applicant to rather not explain his problems, because he'll have a better chance before court to come right for having flaunted the rules. And that, with respect to the rules, is certainly not something that can be tolerated. So, Lords, with respect, we submit the DA has not shown to this court that it is entitled to be here before this court as it is. And this court cannot simply condone something because you will improperly exercise your discretion, because you have not been placed in possession of an explanation. In fact, the only proper course is to deal with the matter on the basis that the applicant, who has the burden, has not placed the facts before this court, and it must therefore fail.
The point regarding the application is premature.
Prematurity,
Yes. I think that's paragraph 8 of your heads.
yes, my lord.
What is your argument on that issue?
Well, there are two aspects. The one pertains to the ad hoc committee, and the other pertains to the disciplinary inquiry. If we can first pause with the ad hoc committee. We've attached the minutes explaining and showing that the ad hoc committee had been appointed. There was notice of this before the application had been launched. It was confirmed very shortly thereafter. And this committee has a mandate. Now, the DA says, well, it doesn't matter what this committee is going to look at. It's simply irrelevant to what has to be decided here. Because the committee, says the DA, deals with other issues. Now, it's important to first consider whether that statement is in fact correct. If one has regard to what the mandate is of that committee, you also find the minutes of proceedings of the National Assembly at paginated page 863. And as we have mentioned in our head argument in paragraph 26, there's a whole list, but it includes certain important aspects as far as this matter is concerned. And that is what we highlight in paragraph 26 of our head.
But according to what the DA argued is that the primary inquiry relates to the ability of the SABC board to discharge its duties.
Lord, the question is not...
And at that time, Mr. Motsoeneng was no longer a member of the board, therefore it doesn't affect him.
Lord, the question is not what is its primary function. The question is what its mandate encompasses.
But what would come of, assuming that committee were to say, we think the board has failed in its duties, it should be dissolved, we think its decisions to appoint Mr. Motsoeneng to this or that position were bad decisions, so what of it? We know that the select committee proposed that all the remaining board members resign. They said not a chance.
Well, Lord, it may be useful.
And that's Mr. Katz's, or one of Mr. Katz's submissions, is that this court is empowered and in fact under a legal duty to consider the rights of the parties and can grant relief. What can the parliamentary committee do?
Well, my Lord, let's first just consider what they have to look at.
Yes.
One of those things is the SABC's board's response to the Public Protector's report. Now that response includes probably more than half what has been said here today. Because the whole of today is effectively about the SABC's response to the Public Protector's report. So to suggest that they deal with something different is simply not correct. How can it be said that a committee who must look at the SABC's response to the report does not traverse the same subject matter as what we've been dealing with here so far today? And it goes further. The mandate includes looking at the issue of the appointments of executives and termination of services of executives affected by the report. Now, no one can surely argue that that doesn't include Mr. Motsoeneng. So to say that the committee deals with something different is simply not correct.
Before we proceed, can someone just assist us?
I can't have this microphone flopping onto my writing pad, so either it must be removed altogether or it must be...
I see yes, the technician coming.
So long as it doesn't sag down again. Keep an eye on it,
Fine.
please.
Okay, thank you so much.
Thank you.
Mr. Bester, you ready?
Thank you. My Lord, the fact is that the ad hoc committee is looking at the same subject matter. It's considering the actions of the SABC board, borate or not. That's not Mr. Motsoeneng's issue. That's a separate issue that the SABC will address and whoever else. The fact is that committee is going to look into that board, the SABC's response to the Public Protector's report, how it acted thereon. Now we know that substantially the remedial actions stipulated in that report pertain to Mr. Motsoeneng. So it can't be said that the committee deals with something different. And that's what the DA suggests. It says it doesn't pertain to Mr. Motsoeneng. And what we have here in this application is the DA saying, well, Mr. Motsoeneng is not allowed to work for the SABC at all. And to bring in the other aspect of premature debriefing, because they are, of course, closely related. Now that the review seems to be common cause should be granted, and that the disciplinary inquiry of last year be set aside, inevitably there will have to be a new inquiry in order to comply with the public protector's report. Of course, there's the issue of the review of the public protector's report that's pending, and that interaction creates its own difficulties. But the reality is, this application seeks to preempt all of that.
Well, that's pitching the DA's case at its very highest. In other words, that there'll be an outcome in this case which bars Mr. Motsoeneng from holding any position whatsoever at the SABC and ceasing to be an employee. If the applicant fails to persuade us to go that far, what the case really reduces to is, was it rational in the circumstances of this case to appoint your client to the position of the corporate affairs executive and the matters relating to the incorrect board and the appointment of Ms. Togwana? Now, the ambit of that is in a sense much more limited.
Well, Lord, that's not really what they're asking.
No, it's not, as it were, their first prize.
Well, Lord, we only see what we see on the head of motion, of course. And there they ask for an order that Mr. Motsoeneng may not work at the SABC. That's it. That's what they want. In the affidavit, they explain that it goes far beyond that in their view, because effectively they say if this court grants that relief, it will also mean, for comparative reasons, that he is not allowed to work for government, for any organ or state. The whole public sphere.
If you take to a more limited proposition that unless and until the public protector's report and remedial action are set aside, it can't be rational to have your client appointed to any senior executive position. How much needs to be said in order to debate that proposition?
Well, Lord, we must consider what the DA's case is here. And I'm attempting to answer the Lord's question with that. Because what we submit is really happening here is the DA is not willing to wait for the outcome of a proper disciplinary hearing.
They're not prepared to have Mr. Motsoeneng in this position for as long as the public protector's report stands.
Well, that is what they're asking for, but the effect thereof.
And it was the effect of what the position was during his pending review of his position as Chief Operating Officer.
No, my Lord, with respect, that's not correct. Because that is not remedial action put forward by the public protector. And this
but it was the position dictated by the court.
Which position? Perhaps I misunderstood.
Skipper's jail, or as I understand it, your client was barred, was suspended pending the outcome of the disciplinary action.
Yes.
And through a series of appeals, he claimed that the effect of that had been itself suspended, so he continued in office. But what I put to you is, you may say his suspension pending the new disciplinary inquiry shouldn't be granted. All I say is how much really needs to be investigated to determine whether he should be allowed to occupy and discharge the functions of a senior executive at the SABC while the public protector's report stands.
So, Lord, we submitted that's the wrong inquiry, and that's what I'm seeking to explain to you. Remember that the suspension was in a different position, CRO. He's now in a different position.
But
so
it was a suspension for reasons. And do you seriously argue that the reasons which made it appropriate for him to be suspended as COO do not apply to the position of Group Executive of Corporate Affairs?
Well, Lord, let's public protector
Sorry,
said,
is there a yes or no answer to my question? Do you consider that the reasons which rendered it inappropriate for Mr. Motsoeneng to be the COO for as long as the disciplinary inquiry went on and was determined do not equally apply to the position of a senior group executive?
we submit it does not simply as a matter of course follow it. That's Mr. Motsoeneng's position. So, if I can take it back a step. The suspension was in a different position. We are now dealing with a totally different position, despite all the statements made about it's just the same story, the same office, the same money, and this and that and the other. There's actually no evidence to back up this serious accusation by the DA that in fact Mr. Motsoeneng is large and in charge of everything and everyone at the SABC behind the scenes. Because that's really what they want the Lords to accept.
No, they may want to accept that in their broadest case, but they also want us to find that given the job description of being a general executive of corporate affairs, and we've got a reasonably full job description of what that is, it is as irrational to appoint him to that position as it is to appoint him chief operating officer. And you say it is not. The findings of dishonesty and maladministration which the public protector made are not disqualifications for the appointment to the position he currently holds. Do you seriously argue that?
We're saying it's not as simple as that. That's where the prematurity argument comes in. And remember, that is really the ultimate aspect that we're discussing at this stage. So if I can go back a step.
I don't understand the premature to what? Premature to the determination of the review in Gauteng?
To three things, in fact. The review in Gauteng, a new disciplinary hearing, and the outcome of the investigation
but
by the ad hoc committee.
How can a new disciplinary hearing, assuming it clears your client, retrospectively render rational what was done in September 2016 when your client was appointed to this office? We are concerned with the quality of a decision which the SABC made to appoint your client to a new position. That was made against the factual matrix of there being a public protector's report with serious findings against your client. If and when that is set aside, or if and when there is a disciplinary hearing which clears your client, it may then become rational to appoint him to high office. But nothing that happens in the future can render what happened in September 2016 rational if it was irrational in September 2016.
Lord, we are Mr. Motsoeneng primarily concerned with the first bit. Of course, he doesn't know what happened behind the scenes, despite what the DA wants you to believe or no evidence. What the details are behind what they see in the second bit. But the first bit simply wants him not to work at the SABC. It's not a matter of comparing the one position to the other position. They say you can't work there. That's their case. That's what Mr. Motsoeneng has been called upon to answer here. The Public Protector's report made a number of findings and then certain remedial actions were stipulated. And of course there's been a huge debate, and we know that there's also the Nkandla saga trying to understand what is the legal position regarding the status of the Public Protector's remedial action, and ancillary thereto, because it was really not the main focus, what the status is of the findings. We know that the Constitutional Court has not said, contrary to what seems to be suggested in generally the talk, in argument, is not, well, that is just 100% binding and full and final and never to be touched again. It says generally, it must be interpreted in what context these findings must hold. It's a matter of interpretation of the report. It's not a one-size-fits-all. And maybe you'll
But Mr. Bester, do you accept for the purpose of the debate and argument that the Public Protector's finding stands as against your client? That includes the adverse findings that were made against him.
We accept that is what is in the report, and that stands until the review takes place.
Now, what Mr. Katz has argued is that, and if I read the press correctly, it appears that subject to that being set aside, as a result of those adverse findings, your client can't be appointed into another position at the SABC.
Well, effectively what that asks is to supplement the public protector's report. Public protector says, these are the findings, this is the remedial steps that I want you to take, as the SABC and the minister and so on. It does not say, I want you to take steps to ensure that Mr. Motsoeneng does not work at the SABC, or something along those lines. There's no such remedial action stipulated by the public protector.
But nevertheless, until those findings are set aside, how does rationality allow, let's leave aside more minor positions in the SABC, how can it be rational? And this is more an argument perhaps for the SABC than for your client, but since you're arguing the point, you may as well make your submission on it. How can it be rational for the SABC to appoint your client to a very senior executive position? Because to some extent the debate about, well, he can't hold any position at all is probably sophistry, because I'm sure Mr. Motsoeneng would find it demeaning, given his recent work history, to be told that he can go back and present the Chappies Little League program. I mean, he doesn't want to do that. So either he's going to be a senior executive, or he's not going to have an actual position in the SABC until these things are sorted out. So I mean, we can debate whether it should go beyond senior executive positions, but that's the real thing, because your client couldn't be expected to occupy a more junior role.
Well, because of the basis on which that relief is sought, it's important. Because although the law probably is conceptually right that at the SABC there's only a limited number of positions that you will find attractive, the basis upon which this relief is being sought will then apply elsewhere as well. So it's an important aspect to consider.
But he's not going to leave the SABC pending the disciplinary hearing and pending the public protector review. He's not going to cut his ties. It's let's wait and see until.
But with respect, what the Lord says is exactly what the DA doesn't want. They want him to be gone.
Yes, but they say until that he can't be employed there, and let us for the moment say in a senior executive position, unless and until the public protector's report has been set aside or presumably been duly implemented.
Now, the Lord...
Your client doesn't say that he would now like to leave the SABC given all of this trouble and go and work somewhere else.
No.
He wants to join the review in Gauteng.
Yes, quite correct. The point I was making, Lord, is that...
So why do we need to concern ourselves with whether our order would prevent him being employed in another public sector organisation? It's not going to happen.
No, the point is that the DA has formulated its relief in wide terms, and we have to deal with it. And we say that to illustrate, because it was the response to my Lord's suggestion that practically doesn't matter, because you only want certain positions in the SABC. The submission in response thereto is that, but it does, because if the DA can obtain an order along those lines, it will also impact on it elsewhere. And that is the reason we're putting that forward. If you also listen up.
Yes.
Thank you. Lord, if we come back to what it is then, assuming, let's proceed on the basis as we all suggest, let's look at simply the new position, as the DA says it's a totally new thing, pending any outcome of the review. The post that Mr. Motsoeneng currently on is different from the one that he had previously. That's a starting point. There's a lot of suggestion that it's lip service, but there's no fact on that, and it's denied, and the job description has been put up before this court, not hidden, So we can accept with respect that it's a different position. We don't want to argue the SABC's case, and Mr. Toy will certainly deal with that aspect, what we've seen in the affidavit about internal arrangements, because pending the review, he's placed in a particular position with different responsibilities, different impact on the organisation.
Well, it's not pending the review. He's been permanently appointed to this position.
No, of course. But
Well, permanently, I say, on their standard 5-year contract.
Yes. But what we have in this application is the DA says, well, the public protector has made certain findings. Taking those findings, it's not good enough to simply have a disciplinary hearing as she suggests is the wrong word, as she stipulates in her report. You should go further and prevent him from working anywhere in the SABC, even in another position. So that's not something that flows from her report, because she does not stipulate remedial action of that kind. She simply concludes factually on certain things. The DA seeks to take those facts further. So they're effectively seeking the laws to supplement what they deem a deficiency in the public protector's report. It's in reality a backdoor review. That's what we're looking at. They do not like that the public protector did not go further and declare Mr. Motsoeneng persona non grata across the board. That, in any event, is an inappropriate manner to go about this. But what they now do is they can say, well, if we take that finding, that is sufficient for this court to decide that Mr. Motsoeneng must be removed out of an employment relationship. And that brings us to the whole argument that has also been dealt with substantially in the head of argument. It's obvious with respect, we'll elaborate on that in a moment. It's obvious that sections 22 and specifically, that more specifically, section 23 of the Constitution, the Bill of Rights, are at play. Mr. Motsoeneng's right to fair labour practice and to pursue a profession are at stake. The DA's application.
Are you now arguing the merits as with the third of your 3 points? There was the non-compliance with service and the rule of prejudice. There was the prematurity point. And are you now as well on the merits?
The Lord, I do not want to move there yet, but I'm bringing this in simply to perhaps bring finality to the prematurity aspect, because it's necessary to understand that in the context of why we say it's premature and why it's appropriate to wait. And it is simply this, that we have these rights, these entrenched, protected rights at stake there. And we'll unpack that separately. And the application by the DA says, well, this court is entitled to allow an infringement upon those rights on the strength of the public protector's finding. Now, when we deal with that aspect separately, we'll deal with how this does not fit with section 36 of the Constitution. But the point for current purposes is this. It is part of the reasons why we submit that it is inappropriate for the DA to now, on an urgent basis, trying to preempt potential outcomes. Mr. Motsoeneng is in a different position. The application doesn't make out a case that he actually causes harm at the public protector, at the SABC. There's no case made out that his current position, and I'm not talking about rationality issue now, I'm talking about the impact that he has on the SABC. A lot of speculation, a lot of accusation, but no fact. So,
but if I understand the argument properly raised by Mr. Katz, is that when a litigant comes to court and raises the issue of legality, then the court must hear that argument. Because what they're raising issue of legality here.
Raising.
Now, whether the committee of Parliament is going to sit and hear other issues, including some that's being debated here, that's one thing. But when the issue of legality is being raised, the court is obliged to hear that matter.
The Lord, what we are saying is that legality also includes the legality of infringing on Mr. Motsoeneng's entrenched rights. That is really the essence there. And why we brought this in at this point, whilst we're in fact going to deal with it in a bit more detail later on, is because of those infringements. It's relevant to why we say this matter is premature. On this basis, perhaps if I can just pick up where I left off a moment or two ago. Mr. Motsoeneng is in a different position. No case has been made out that in that position is a danger, and I use the word loosely to encompass all the allegations made by the DA. That case has not been put on. So what they're saying is, there's a review, there's a disciplinary hearing, there's a portfolio committee. We're not interested in those outcomes. It must now be decided whether it is proper for him to be appointed in that new position on the basis of the public protector's factual finding, which is subject to review. So,
yes, but he's talking about jumping the gun and coming prematurely. Isn't the jumping of the gun to appoint Mr. Motsoeneng to another very senior position while the public protector report stands? That's the jumping the gun, and that's the complaint of irrationality in the appointment.
No, with respect not, my lords, because he's still an employee. They make...
Yes, no, I appreciate that for as long as you put the DA's case at its very strongest, that we must make an order which terminates his employment, you are likely to have a considerably stronger argument. But as soon as one reduces it to what I see as the essence of the case, which is it rational to have appointed him to the position he now occupies, and for present purposes we can talk about any senior executive position. It seems to me that it must be premature for the board to have done it when it has not yet succeeded in its review and is in the meanwhile bound by the findings of the public protector.
Just before you answer that, the current public protector in her affidavit, and I've raised this earlier, paragraph 39, also emphasized that the present appointment of Mr. Motsoeneng, particularly a position of authority and leadership, would be improper until such time as the SABC's application for a review has been finalized.
Or one may add, or until a credible internal disciplinary process is cleared. That might be another condition, but we don't have to concern ourselves with that, because neither condition had been satisfied when your client was appointed to this position 2 months ago.
We'll perhaps to deal with the latter point first. Yes. With the greatest of respect to the public protector, that is simply an opinion. It weighs no more than the arguments presented here before this court.
Of the current public protector? Is this an opinion of her?
Yes, with respect, because it's not this public protector's report. She's not, she's making a statement, or she's postulating an argument as to what it should be. The report doesn't say it. The report is a document that must be interpreted like any other document, whether it's a contract, whether it's a statute. That's how it must be dealt with. And the public protector's opinion as to what was meant in that document by a predecessor, with respect, doesn't take the matter anywhere. So it doesn't carry its own weight. To come back to the earlier, or the related aspect, we have a situation where Mr. Motsoeneng is still an employee. Mr. Motsoeneng is still with the SABC. The SABC is in a process of reviewing and in a process of battling, if I can put it in those terms, with the disciplinary inquiry, because it's finding its way, rightly, wrongly, with whatever approach. That is the SABC situation, not Mr. Motsoeneng's. It takes time. This is all fresh. The Constitutional Court, the Supreme Court of Appeal, this court, had to dissect and analyze and consider these issues. There are still a whole lot of loose bits and pieces whether it's administrative action or not, and things like that. It's taken 2 years to figure this out to the point that it has been figured out, with the greatest of respect. So the SABC is in a position, and of course, I'm not suggesting this is its view, Mr. pt2 will deal with that, but from the perspective of advancing Mr. Motsoeneng's case, the SABC is in a position where it must grasp with these issues. It must practically deal with these issues.
And you say one of the rational ways it can do that is while it's grasping with the binding nature of the Public Protector's report and trying to review it, and having followed an ineffectual internal disciplinary process, the appropriate step is in the meanwhile to enter into a 5-year fixed-term contract with Mr. Motsoeneng to occupy this new position.
Well, my Lord, if there's a different outcome later, of course, steps can be taken. That 5-year contract should not be the focus, the fact that it's 5 years.
But if I come back to this, if it was irrational in September 2016, how could it be made rational by anything that happens afterwards?
No, my Lord. We're not suggesting that it was irrational. Firstly, we must just make that clear. We're not suggesting that it was irrational in September, because what we're saying is it's a rational attempt to regulate affairs until the matter has been resolved.
That's not what it says. The decision is a 5-year contract on the same remuneration terms as his position as acting COO.
And that's why we're saying, my Lord, one should not simply look at the fact that it's a 5-year contract. Because if the review file, if the disciplinary hearing has an outcome which says his services must be terminated, clearly that 5-year contract is not going to save the day. So
well,
with respect...
But Mr. Bester, are you serious with that proposition? Because it means that the SABC, which uses public funds, must pay out Mr. Motsoeneng for the 5-year contract.
No, my Lord, with respect, that's not what will happen. If the disciplinary inquiry, or even a subsequent disciplinary inquiry, depending on the outcome of the review, finds that he should be dismissed, as a matter of law, there's no payout to him. That's how those things work with respect. So there's no public money that's being wasted. So it's with respect to red herring, the fact that it's a 5-year contract. If there are good grounds to dismiss him as an employee after having dealt with properly with matters from a labour perspective, it will not matter whether his contract was indefinite, subcontractors agreement, 5 years, or whatever the case may be. So it's a red herring with respect. In terms of...
But you haven't answered my learned colleague's question. If it was irrational before, what makes it rational now?
I'm coming back to that. Can I ask Lord to briefly...
I understood your answer to be it was rational.
Yes.
In September 2016. And that's what I really battle with. If I look at the SABC as a public body, with a charter, with everything that has been said about the importance of its work, and then say, do these findings, which made it inappropriate for him to be appointed as a COO, nevertheless leave room for him to be appointed to this new position? You are saying, well, the position of Group Executive Corporate Affairs is sufficiently less august that we can in fact have a person who, on current findings, misrepresented his qualifications, was guilty with widespread maladministration of the SABC. Just take a moment to think before you answer that question.
Yes. Lord, what we say is, firstly, that's for the SABC to deal with. We see in the papers it is its approach that it was rational in the circumstances, because it's a matter of circumstances. And we leave that mainly for them to argue. But the essence of what we will submit is, if the Lords have regard to page 926. 926. It's simply the organogram, so if it's not at hand, it's not perhaps supposed to not respond. And the Lords will see is the organizational structure. The simple point we want to highlight there is the difference in the position. If one has regard to what in this organogram where the Chief Operations Officer is placed, where the General Executive for Corporate Affairs is placed, they're vastly different in that structure in terms of powers and responsibilities. And so what we are saying is, as a measure to utilize Mr. Motsoeneng, whilst it is determined what must happen in the disciplinary inquiry, and related to that in the review of the public protector's report, and what will come of the ad hoc committee. It's not irrational, because it would be perhaps even more objectionable if he is paying a salary, because they can't not pay him until, and let him do nothing until such time as these things are resolved. So the mechanics of why, what is rational, what is the better decision, Mr. Du Toit will deal with, I would assume. But what we are saying is, he's an employee. He's there. He can't just be fired, whilst there will still have to be a disciplinary inquiry to deal with the issues raised by the public protector. The public protector requires the SABC to implement what those findings were, to decide rationally how to deal with the findings against Mr. Motsoeneng. Even if the public protector's findings stand ultimately in the review, it is still so that there will be a disciplinary hearing. We now know that there will have to be a new one, which will decide those issues. The DA suggests, well, before you have the disciplinary to decide whether his services should be terminated or not, or however else you want to deal with it, you should terminate it now. And you should terminate it now for the simple reason that in the meantime, the manner in which they try to accommodate the public protector's findings, whilst they deal with the public protector's remedial action, is simply so irrational that we can't wait the few months that it will take to resolve all three of these issues: review of the public protector's report, disciplinary hearing, outcome of the ad hoc committee's inquiry.
But we know that a couple of months isn't what characterized the previous proceedings concerning his position as Chief Operating Officer.
That may be so good, but of course, there was a total lack of understanding, broadly speaking, about what it means to have the public protector's report. What must be done with it? The President of the country had said eventually, well, now I understand what the status of that report is. So it can hardly be a matter where Mr. Motsoeneng is now blamed, and he must now be terminated summarily, because that process had everyone in the fray, went through all the courts of the country to be figured out, and only partially so with respect. And that's where we come back to the issue of the conflicting rights. Lord, may I perhaps at this stage an indication of what the Lord's thinking is regarding proceedings until when we will sit today and the like? That's the plan.
It's 3:45. We will sit until 4 o'clock. We will sit until 4 o'clock.
Thank you.
Unless you would require an adjournment until tomorrow morning.
Well, it will be more than 15 minutes more. It's not a matter of really adjournment, but I will start with a new topic. If the Lord does not mind that it be broken up.
I think it's better to carry it. Don't leave yourself short for something. Maybe use the last 10 minutes.
Let's use another 10 minutes and then we can adjourn after that.
As it is. Thank you.
Unless you feel that it's best that we adjourn now and resume tomorrow. It depends on you, but I think we must use the 10 minutes. What do you say, Mr. Du Toit? You are nodding your head in agreement.
I only want to stress that I also need time, so he must use the time.
The Lord, my legal team here suggests that we may be more efficient time-wise if we start tomorrow morning. It's hardly useful to have 10 minutes now and through that take up another hour tomorrow, and we would suggest that perhaps it's more appropriate that we see what really needs to be said and try and finish quite quickly tomorrow morning, if the laws will allow that.
Does that imply you'll be shorter tomorrow in your argument?
That is certainly what we will endeavour to do, shorter than it would otherwise probably be.
I think the understanding was that the respondents, the 3 respondent teams, could have until lunchtime tomorrow. So we need to speak to Mr. Du Toit and Mr. Nechi just to find out how much time, respectively, they think they will need.
We appreciate it. Thank you.
So, Mr. Du Toit, it appears that you will be a bit shorter tomorrow as well.
It seems to be a straitjacket in which my learned friend is putting me.
Mr. Benenke, are you happy with our...
We have narrow plans.
So you've got no objection if we adjourn a bit earlier? The court will then adjourn until tomorrow morning, 10 o'clock?